Imagine this. You've spent decades building your wealth. You've got real estate, a thriving business, a retirement portfolio that could make a hedge fund manager blush. And then out of nowhere, a lawsuit. You lose in court. You appeal. You lose again. And now they're coming for everything unless you did this one thing before the lawsuit hit. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been in the asset protection business for 34 years and setting up Cook Islands trusts for nearly 30 of them. We've established more Cook Islands trusts than any firm in the world. And if protecting your wealth matters to you, subscribe now and stick with me because I'm about to show you how to make your assets lawsuit-proof even if you lose in court. Okay, let's get one thing straight. Most wealthy people in the U.S. think they're protected. They've got an LLC, maybe a family trust, maybe they put everything in their spouse's name or bought a house in Florida under homestead laws. I see this every week, but here's the truth. Domestic asset protection is like building a moat in a swamp. When the flood comes, when that court judgment hits, state judges can walk all over it. And I see it all the time. They can seize the LLC, freeze your bank account, garnish your wages, and yes, even reverse that family trust. So here's a stat. In the U.S., over 40 million lawsuits are filed every year. That's one lawsuit every 2 seconds. And once that lawsuit starts, judges can and will claw back any assets they think that you're trying to hide. But what if they couldn't reach them? Now let's talk about the legal bunker that actually works, the Cook Islands Trust. Now, what makes it special? Simple, jurisdiction. The Cook Islands doesn't recognize U.S. court judgments or UK court judgments or Australian or New Zealand, wherever you are. So when the judge pounds their gavel in your jurisdiction and says, turn over the assets, our trustee in the Cook Islands says politely, I'm sorry, Your Honor, but our laws stop at the beach. No, seriously, that's how it works. To pursue a claim in the Cook Islands, a creditor would have to hire a local attorney, and they're expensive and picky, post a bond up front with that lawyer, often in the 6 figures, start their case from scratch under Cook Islands law, prove the case beyond a reasonable doubt. That's right, the criminal standard, not just a preponderance of the evidence, which is 51 to 49%, but 97 to 3%, and do it all within a tight statute of limitations window. Pay out of pocket because contingency fees are banned in the Cook Islands. Sounds exhausting, right? And that's the point. So let's walk through how we build this armor because the magic is in the details. So here's how we do it at Asset Protection Planners. Here's the Cook Islands Trust represented by this purple rectangle here, and that's the heart of the structure. You, the client here, are the grantor of the trust and the beneficiary of the trust, both. You control nothing directly, but you benefit from everything. Now, what we do here is we stick an LLC inside the trust that you do control. You're the initial manager, signatory in the bank account, and the only time the trustee steps in is when the court would take your money. So we appoint a licensed, bonded trustee company law firm in the Cook Islands, highly vetted. I have a Cook Islands trust myself. They follow your instructions, and until somebody sues you, they're in the background. So when the lawsuit strikes, they step in. Now, they're not subject to U.S. courts. They can't be forced to turn over your money or comply with U.S. court orders, and that's when the firewall goes up. Next, we talk about the Cook Islands LLC that we just mentioned in a little bit inside the trust. We create a Cook Islands LLC, and here's the twist. Like I said, you're the manager. This means that during peaceful times, you call the shots. You control the bank account. You move the investment. So you're in the cockpit, but when legal turbulence hits, you can resign as manager. The trustee steps in as manager temporarily. Your assets locked down. U.S. courts don't have jurisdiction over our trustee company law firm. Your assets locked down, out of reach, out of sight. Step 3, offshore bank account. Okay, so when we open an account in a jurisdiction that respects privacy and ignores foreign judgments, your money is safe when it's in the trust. Switzerland, Liechtenstein, even the Cook Islands itself, they all have excellent banks. The LLC here owns the account. So you can see the LLC holds the bank and investment accounts, not you, because if you own them directly, the courts could order you to turn them over. So if a creditor says, freeze the account, the bank replies, we're sorry, we don't recognize that order. Now here's the kicker. You're not hiding anything, you're simply unreachable. Let me tell you about a real client. We'll call him Mark. He built a SaaS company, software as a service, from scratch. He sold it for $42 million. Smart guy, but also a realist. Before the sale closed, he came to us and said, guys, I don't trust California courts. I want this money somewhere I can sleep at night. So we set up a Cook Islands trust with an LLC inside of it, structured the proceeds to land in a Swiss account held by the LLC, and left Mark as the manager. A year later, a former co-founder who had long been bought out came back with a lawsuit, claimed he was owed 10%. Lawsuit gained traction, went to trial. Mark lost. Guess how much they recovered from Mark? Zero. The trust had been set up in advance. The statute of limitations had passed. The assets were no longer under the U.S. jurisdiction. Mark had full access to the account, online, could do his stock trades, had a debit card to be able to access funds. So Mark's lifestyle didn't miss a beat. Mark didn't evade a judgment. He planned ahead, and that made all the difference. Okay, now let's address the elephant in the room. Can you do this after you're sued? And the answer is yes, you can, but it's going to cost more, and you'll be under more scrutiny in the courtroom. So let me repeat that louder for the people in the back. Yes, but it's going to cost more. It's called a high-risk situation, and there's more liability for our firm and the trustee company law firm. And if you're already sued, or even if you're not for that matter, that's why U.S.-based asset protection doesn't work very well. U.S. courts will undo a transfer if it's within their jurisdiction, under their control, if it was made after you knew legal trouble was on the horizon. Not even after you sued, but you knew something might be coming and you move assets around. If it's a U.S. asset protection plan, the courts are going to get it out of that plan. That's why the smart clients, real estate developers, doctors, business owners, they do this now, and they do it offshore when the seas are calm. Because when the storm hits, your legal boat gets tossed around a whole lot more. Now, here's another question I get all the time. Hey, business guy, what if someone tries to look up my assets? Will they find it in the trust? Short answer, no. The Cook Islands doesn't publish your name in a public registry. There's no searchable database, no online trail. Same goes for the offshore bank account. And here's a bonus. In many cases, we pair the Cook Islands LLC with a Wyoming LLC. Say you have to operate your U.S. operation, and that acts as the U.S. face of the operation. So that's an extra layer of domestic privacy that can tie into everything. So we pair this with a nominee manager to keep your name out of the public records on the Wyoming LLC, and a Wyoming virtual office address and phone number. So even if somebody hires a private investigator and looks through every U.S. county courthouse, they'll see a Wyoming LLC. It doesn't have your name on it, and that's it. No names, no trail, just peace of mind. Now, here's another fun one. Why don't more attorneys recommend this? Well, why don't all doctors do brain surgery? Because it's not their specialty. Why? Because most lawyers practice what I call reactive law. They wait until you're sued. They fight the fire instead of fireproofing the house. Also, frankly, it's specialized. This is international trust law, offshore compliance, and many firms don't do this because they can't. They don't know how, but we do. It takes a law firm like ours that specializes in asset protection, and we've been doing it for 3 decades. I've personally been doing this for 34 years, and we've helped protect billions in client assets. So we don't help you hide. We help you become legally untouchable. In fact, you can even publish the assets that you have on a billboard across from opposing counsel's office, and you're still protected. So it's not hiding, it's actually protecting, because what's hidden can be found. What's actually protected is protected, even if the other side knows that it's there. Hiding doesn't work. So let's flip the script. What happens if you don't set this up? You leave everything exposed. Let's say you're sued for $2 million. You fight it in court, you lose, and the judgment stands. Now what? What happens next is the creditor's attorney will subpoena your bank accounts, put liens on your properties. They'll garnish your rental income, take those properties, go after your business interests, even seize your retirement if it's not ERISA qualified. And if they see you moved money recently, that's called fraudulent conveyance, and now you're in deep water. Now, fraudulent conveyance is a civil matter, but it allows the judge to take the assets away from wherever you moved it. You move it to mama, now they sue mama. So here's the truth. Doing nothing is the riskiest thing you can do. Okay, now let's be honest. This isn't for everybody. If you've got under $500,000 in assets and no lawsuit risk, this may not be the right tool for you. But if you're a business owner, if you have multiple properties, if you've worked decades to build real wealth, and if you understand that the legal system doesn't always protect the innocent, then this is for you. Because once you've built a fortune, the number one threat is not the economy, it's litigation. Okay, so what now? Go to assetprotectionplanners.com. You get a lot of free information there. We offer a free consultation for those with over $500,000 to protect. We walk you through exactly how we would structure your protection plan. No pressure, no sales pitch, just strategy, and we listen to your situation. Look, lawsuit happens. That's the game. But losing everything, that doesn't have to be part of it. The wealthy don't just make smart investments, they make smart protections. And that's what we do, quietly, legally, powerfully. I'm the business guy with Asset Protection Planner. Subscribe to the channel. You want an asset protection guy in your side, and hope I'm that guy for more insights like this. And if you're ready to protect what you've built, let's talk, because once the lawsuit hits, sometimes it's too late.